with you.
Yeah. Can he?
If he can't stand up.
Okay, we'll just see how it goes. Mr. Hutchins, good morning, sir. Come on up. Mr. Hutchins, would you prefer to stay where you are? Would you like to be assisted into the witness stand? Your choice.
Yes, thank you.
Okay, all right. Let's see if we can't. We're going to turn you so everybody can see you. Okay. To begin with, is that okay? All right. Christine, you okay?
Yes.
All right. All right. Mr. Hutchins, let me get you to raise your right hand if you're able to do so, sir.
Raise your hand. You
All
swear.
right, go ahead.
You swear affirm the testimony you give today the truth, the whole truth, nothing but the truth?
Yes.
Speaking to the mic.
Yes.
All right, state and spell your first and last name for the court. So you go with your head down. Speaking to him.
My first name is Dwight, D-W-I-G-H-T. My last name is Hutchins, H-U-T-C-H-I-N-S.
And good morning, Mr. Hutchins. How are you?
I'm good.
And Happy New Year to you.
Thank you.
Mr. Hutchins, do me a favor. I want you to yell in that microphone, okay? So we can all hear you, all right? Or I'll put it this way, use your outside voice. Let's see how that goes. Can we do a test?
Testing.
All right, okay. Just try and keep that level up, if you wouldn't mind for us, okay?
All right.
All right, thank you, sir.
And Mr. Hutchins, where are you from?
Atlanta, Georgia.
All right. And do you currently reside within the Metro Atlanta area?
No, I live in Loganville.
Okay. And how long have you been in Loganville?
Like a year and a half.
You said a year and a half? Okay. And are you currently working?
No,
Why aren't you working?
because I had a stroke.
How long ago did you have your stroke?
Back when COVID started, 2020.
And with you having a stroke, has it affected your memory at all?
Yes.
Now, let me ask you, prior to having a stroke, did you work?
Yes.
What type of work did you do?
Security.
And how long were you in the security industry?
Give us think about 25 years.
25 years. And while in the security industry, did you ever work for Velour Security Services?
Yes, I have.
And if you can recall, approximately when did you work for Velour Security Services?
About from 2013 to 2015.
And when you worked for Velour Security Services between 2013 and 2015, did you have a particular location that you were responsible for securing?
It was the whole mall.
And when we say the whole mall, which mall are you referring to?
Perimeter Mall.
And did you work at Perimeter Mall for that entirety of that 2013 to 2015 period?
Yes.
When you worked at Perimeter Mall, what were some of your job duties and responsibilities?
To help out people to go to accident scenes, wherever it may be.
He said to go to accident scenes. And you shook your head, is that a yes?
Yes.
And is that accident scenes within the mall?
Yes.
Did you ever have the responsibility for patrolling outside of the mall as well?
Yes.
Within Perimeter Mall, was there a particular unit or area where the security team was housed if you weren't patrolling? Did you have an office area?
Yes.
And in that office area, was that a shared space or did you have your own individual office within the security office area?
All of the officers shared that area.
And was that area a secured area?
Yes.
And just generally, if there was an incident that occurred at the mall, say an accident or anything like that, would you have to make an incident report, an internal incident report?
Yes.
And generally, when there was, say, an accident at the mall, did you always have to call outside law enforcement, or was that only on certain occasions?
No. It was only a certain occasion.
Why would you have to call law enforcement out?
If somebody slipped and fell and hurt themselves, well, catalytic converters, things of that nature.
And we say Cadillac converters, what do you mean?
They were cutting them off.
They would cut them off at the mall.
Yes.
Like people would come up and cut off people's Cadillac converters.
Yes.
If there were any crimes like theft, would you have to call the police?
I wouldn't have to call him per se.
Okay. Who would have to call?
Mr. May.
Mr. May. And who is Mr. May?
He's director of security.
He was director of security. And was Mr. May your director of security the entire 2 years that you were at Perimeter Mall?
Yes.
As your supervisor, what was some of his responsibilities? As Mr. May, he was your supervisor?
He was over the whole department.
And do you know, as his job over the entire department, some of his responsibilities?
No.
Would he sometimes be called to assist you if you needed assistance?
If I called him,
Now, I want to direct your attention to July of 2015. Were you working for velour services at Perimeter Mall?
yes.
And taking you back to July 2015, which is a while ago, did you have the occasion to encounter a group of men on hoverboards?
Yes.
If you can tell the jury, what do you remember about your first encounter with them?
Well, my first encounter was when I spoke to him, I explained the policy that it could be injured and liability issue. One guy stepped down, and then the other guy said, get back on your board.
So how many guys were on hoverboards?
So,
And you were explaining to them why they could not be on hoverboards?
yes,
Right. And was that part of the mall policy why they could not be on hoverboards?
yes, due to liability issue.
And I believe you just said, I just want to clarify that when you spoke to them, one person got off the hoverboard, the other remained on the hoverboard. And you're shaking your head, is that a yes?
Yes,
And the one who stayed on the hoverboard, I believe your testimony was, he told the other person to get back onto their hoverboard.
correct.
Once that occurred, what, if anything, did you do as it relates to those two individuals still on their hoverboards?
I just kept explaining the policy.
And did they say anything to you as you kept on explaining their policy? Your policy, though.
They said they were leaving.
What was their demeanor?
Again, toward me, it was all right.
I'm sorry, say that one more time.
Toward me, it was okay.
Towards you, it was okay. All right. Now, when they did not get off of their hoverboards, what did you do?
I called Mr. May.
And why did you call Mr. May?
That's for his job. When I can't help something, I call him.
When you can't do what?
Handle something.
And when you say you can't handle something, what couldn't you handle with this particular incident?
Well, they kept riding, and I ain't gonna put my hand on nobody. So I called him. Let him explain it to him.
And were you able to reach Mr. May?
Yes.
All right. And did Mr. May, what happened with Mr. May?
He asked for my location. They came to my location.
All right. And what location were you at the time?
Champs,
And what type of store was Champs?
a shoe store.
And when Mr. May got to the shoe store, what happened?
I advised him of my situation, and he went and spoke to him.
And what happened when he began to speak with them?
And they were leaving, so he said they're leaving anyway.
And what was their demeanor like when they said they were leaving?
I mean, I don't know what you mean by it.
Okay.
Were they hostile or what?
Yeah. How were they acting?
They were acting normal. They were just riding.
They were just riding. All right. All right. And did they get off the hoverboard?
No.
All right. What happened next?
We escorted them to the front of the mall, up the escalator.
And were they still on the hoverboards when you
Yes.
escorted them out the mall?
Yes.
All right. And what happened after you escorted them out the mall?
We escorted to the valet where they were parked.
All right. And did you go down to the valet area where they were parked?
Yes.
All right. What happened once at the valet area?
During that time, I kind of checked out because we already got them at the mall, so it's all good.
Okay. You said you checked out because it was all good at that point. All right. What if, did you hear them saying anything at that point?
I just heard a lot of profanity.
And who was giving profanity?
I'm not sure.
Oh, you don't know which one? Okay. Do you remember anything specific that they were saying?
No.
And you said they were yelling profanity. Was it the individual on the hoverboard yelling profanity?
Just the guys in the car.
Just guys in the car. How many guys were in the car?
3 or 4.
And today, so you don't recall what they were saying?
No.
No. Okay. Now, back in 2015, did you have to make a report to the police regarding what happened at the mall with these two individuals on hoverboards?
I don't think they were in a police report.
Did you ever remember talking to the police about what happened?
No.
You don't remember? Okay. I'm going to, do you ever remember writing a statement?
No.
Okay. Do you ever remember seeing a statement with your signature on it?
Yes.
All right. Permission to approach, Your Honor? I believe the defense counsel all has this statement, but I'm going to show this to Mr. Hutchins. Ms. Hutchins, I'm going to show you what's been marked as State's Exhibit 190P. And looking at State's Exhibit 190P, do you see your signature on State's Exhibit 190P?
It looked like mine, but it's not mine.
It looks like your signature, but it's not your signature.
That's how I write now.
That's not how you write now.
I write like this now.
Okay, but back in, you're saying, but back in July of 2015, that's not how you wrote.
No.
All right. Let me ask you, looking at that document though that has your name on it, is there a date indicated on that document?
Yes.
Yes. Yeah, but you have an objection? Yes. Basis. Basis.
A document has been disowned. There's no foundation.
Foundation, okay, that's what we're looking for, all right.
Your Honor, it's impeachment. And he's saying, I don't want to do a speaking.
Okay, all right. I'm gonna overrule your objection, so you may proceed this time.
Is there a date on that document?
Yes.
Okay, what is the date?
7/7/2015.
Okay. And in looking at the document, you've had the opportunity to read this document previously?
Yes.
Okay. And is this document written in first person, meaning as if you wrote the document?
Your Honor, same objection.
Given what I've learned already by the witness, I'm gonna give him a little attitude, Mr. Steele. I'm gonna overrule your objection, okay? Ordinarily, I wouldn't allow them to leave, but I'm gonna, in this particular circumstance, make an exception, okay?
Is it written in first person?
Yes.
Okay. And so it says, I, Officer Hutchins, right?
Correct.
Okay. And this document also has a date in which it was written, right?
Yes.
What is the date that the document was written?
July 7/2015.
All right. And this same document was written closer in time to the incident that we're referring to, which was July 2015.
I can't say.
You can't say, but there's your signature.
It looked like mine, but it's not mine.
All right. And there's a date of July 7, 2015.
Ask and answer.
I stand the objection.
And today you're saying that you did not write this statement.
I don't recall
You don't
writing
recall.
this statement.
Okay. All right. And you do not recall writing the statement.
Correct.
Okay. Thank you.
Who made that objection? I'm sorry?
Objection as an answer.
I sustain the objection.
Now, a few weeks ago, do you recall one of my investigators coming to your home?
Yes.
All right. And when my investigator came to your home, did the individual show you this document?
On his phone, yes.
Okay. And do you recall what you told him about your signature when he showed you the document on the phone?
Correct.
Okay. And what did you tell him about your signature?
I said at that time, it looked like mine.
Okay. And this same signature, was this the same document that he showed you on the phone?
It was so small I could hardly see it, but it looks to be the same.
It looks to be the same document. Okay. Now, Mr. Hutchins, as it relates to, you said that you kind of had to escort these individuals from the hoverboards out of the mall. Was this your first time ever having to escort anyone out of the mall?
No.
And when you previously had to escort individuals out of the mall, do you always have to call the police when you're trying to escort individuals out of the mall?
Objection relevance.
I sustain the objection.
On this incident day, back in July 2015, were the police called after this interaction with the individuals on hoverboards?
Yes, they were called, but I didn't call.
You did not call, but they were called. All right. Now, back in 2015, when you first encountered the individuals on hoverboards, did you know their names or who they were?
No.
Back in 2015, is it safe to say you had never met those individuals prior to that interaction that you had with them on the hoverboard?
Correct.
And at the conclusion of the interaction with those males, did you learn their names at any point in time?
After he left the mall,
How did you learn their names once they left the mall?
well, they are people that recognized them.
People at the mall had recognized them?
Right.
And who did you learn it to be?
Well, I don't remember the name.
You don't remember who it is. All right. I'm going to show you what's already been admitted as State's Exhibits 184P. And I'm going to hand this to you. Sure. So, 184. Mr. Ernst, and Ms. Sharon capabilities. And Mr. Hudson, I'm gonna show you right here. And for the jury's on the screen, Stacy did a 184P. Have you seen that picture before?
Yes.
Okay. And do you see yourself in Stacy's in a 184P?
Yes.
And you can tell the jury, where are you at in Stacy's in a 184P?
At the top of the escalator.
Okay. And at the top of the escalator, there's two individuals. Which one are you?
I'm the one on the left with the flight jacket.
With the flight jacket, with the vest on? All right. And now I'm going to show you what's been marked as Stacy's in a 185P. And have you seen that picture before?
Yes.
All right. And looking at Stacy's in the 185P, do you recognize the individual in 185P?
I don't recognize him, but that's the gentleman that I spoke to.
That's the gentleman that you spoke to. And when speaking about the two individuals, initially one stayed on the hoverboard and one came off the hoverboard. The individual in 185P, which one was he?
He was the one that said, get back on your hoverboard.
Okay, so he's the one that stayed on the hoverboard and directed the other person to get back onto the hoverboard. You're not,
Yes.
Yes. Okay. And down at the valet, when you said that people were cussing, was he one of those individuals that was cussing down at the valet?
I don't know.
You don't know.
I didn't see him per se
Okay. So that's your testimony today. You did not see him per se.
because, like I said, once we got him out the building, I kind of checked out because we already done our job.
Okay. And you were the one who first had the first interactions with these individuals?
Yes.
And you were the one who called Mr. May?
Yes.
All right.
I'm gonna overrule the leading. I'll sustain the repetitive.
I have no course indulgence.
All right.
Just one last question, Mr. Hutchins. Earlier, you said that the demeanor, earlier, you testified that the demeanor, that they weren't fussing and cussing towards you. Were they fussing and cussing towards anyone else earlier in the day? Earlier in your interaction?
No,
No, you don't recall that.
they were not.
Hold on, basis. I'm gonna overrule the objection.
Also object, Your
I'll overrule the objection. I'll overrule the objection as to yours. One at a time, gentlemen. Mr. Matthews, yours is overruled, or yours is, yeah, overruled. What's your objection, sir?
District Attorney mischaracterized the answer.
I'm gonna overrule your objection. Jury will be determine what they heard, okay? All right, anything else? All right,
I have no further questions.
any examination of Mr. Hutchins, gentlemen?
Very brief.
Okay, come on.
For ease, question in that corner.
You may, sir.
Good morning, sir.
Good morning.
We all hope that you feel better and keep recovering.
Thank you.
Do you, have you read what was shown to you as a number 190P? It's that document that the district attorney was asked you.
This is Alaska. Some questions just don't have answers.
You know where that document is right now by any chance?
No, the original.
Yeah, is that it right there? Your Honor, may I approach 1 second?
You may.
May I approach you, sir?
Yes.
I'm going to show you this, and if you can't read it, just let us know, okay? I see you with reading glasses. With your permission and the court's permission, I just want to ask you a couple of questions about that document, okay? The district attorney was saying that it was written. Is that a written document or a typed document?
It's typed.
Okay. And the only part written would be at the bottom of that document, is that fair to say?
Yes.
With a, I'm not saying, I understand, you know, it's your testimony, purportedly, meaning potentially or seemingly your signature and then the date of 7/7/2015. Is that true?
I mean, what's the question again?
That's the only handwritten part
Yes.
of 190P. Okay. And in that document, even the type part, you never mentioned anything about any of the people on the hoverboard being rude to you or Mr. May in the mall. Is that true?
Correct.
And what you do write is that you were being ignored and Mr. May was being ignored about your warning to please get off the hoverboard, and it could be a dangerous situation for them as well as others. Is that fair to say?
Correct.
And the people on the hoverboard made it known and they did leave the mall. Fair to say?
Yes.
And then they went peacefully to their car.
Yes.
And at that point, the way you recall is it was pretty much they were leaving. It was over. Any issue was over. Is that fair to say?
Yes.
Okay. But then in this statement, the 190P, it's written that Mr. May continued to ask them to leave the property. And I stress this, one of the males shouted he would come back and shoot Mr. May in the face. Do you remember that? Right, at least that's what it says. The last 2 lines.
That's what it says.
Okay. And you never identified anybody as saying that? You were just saying that it came from the car, fair to say? If this is yours.
Well, all I heard, like I said, was a lot of profanity.
Okay. All right. And you don't know Mr. Jeffrey Williams, do you?
No,
And you don't know a performer known as Young Thug personally, do you?
no.
All right. Thank you so much for your time. I can take that from you unless you need to see. Thank you, Your Honor.
Anyone else? Anything further from the state?
Mr. Steele just asked you if you knew Mr. Young Thug personally. Once this incident was over, did you learn if Young Thug was one of the individuals on the hoverboard?
Yes,
Yes, you did, but you did not know him personally.
no.
All right. And Mr. Steele asked you a lot about the statement that I asked you about earlier. And again, looking at State Exhibit 190P, today your testimony is that you heard a lot of cursing. Looking at 190P and that last line, what is in that statement regarding what the individual in the car said upon leaving the location? So regarding that statement, do you have any memory writing that statement?
No,
You have no memory writing that statement. And is your testimony today that you did not provide that statement to police officers?
I don't remember providing this statement at all.
Okay,
There's some things wrong with it.
all right. Thank you. No further questions.
Anything further?
Don had this way.
All right. Anyone else? Okay, may Mr. Hudson's be permanently or temporarily excused as a witness?
He can be permanently excused.
All right, Ms. Hutchins, I'm going to permanently excuse you as a witness. Thank you for your patience with us. And please don't discuss your testimony with anybody except the attorneys in this case, okay?
All
All
right,
right, thank you, sir.
thank you.
All right, call your next witness.
Your Honor, state calls Mark Stevens to say.
All right, summon Mark Stevens, please. Mr. Stevens, good morning, sir. Sir, if you could please approach the witness stand. Once you get there, if you'd be so kind to turn and face Sergeant Ingram, who's sworn as a witness before you sit down.
Yes, sir. Raise your right hand. Swear affirm testimony you give say the truth, the whole truth, nothing but the truth.
I do.
Absolutely. State and spell your first last name for the course.
Mark, M-A-R-K, Stevens, S-T-E-V-E-N-S.
Mr. Stevens, good morning, sir.
Good morning, sir.
Mr. Stevens, are you currently employed?
I am not.
Where did you work prior?
In November, I retired as a police officer from the Dunwoody Police Department
Okay. And prior to your retirement, where did you work prior to your retirement?
with the Dunwoody Police Department.
How long did you work for the Dunwoody PD?
Almost 15 years.
Mr. Stevens, what units were you assigned to during your time with duty?
When I was hired as a patrol officer. In 2016, I was transferred to the community outreach section.
What were some of your responsibilities as a patrol officer?
To answer 911 calls or any other call for service, enforce traffic laws, and those were our two primary.
And what years were you assigned to the patrol unit?
I started in 2009 with the Dunwoody Police Department and I was a patrol officer until January of 2016.
And were you court certified during this time?
Yes, sir, I was.
So on or about July 7th, 2015, did you respond to a call at the perimeter mall?
Yes, I did.
What was the nature of that call?
It was a threats call.
After you arrived on scene, who did you speak with?
I met with the Director of Security, Chris May.
And to your knowledge, was the person who made the threat still on scene?
No.
Were you given any vehicle information to identify the person who made the threat?
Yes, sir. It was a white four-door Jaguar with a partial Georgia temporary plate.
And were you able to get any information with this partial tag?
No, sir. Unfortunately, there was a digit missing, so no returns were available.
Mr. Stevens, who else did you speak with to identify the person who made the threat?
After I spoke with Mr. May and I both spoke with a gentleman named Reggie. He's the manager at Champ Sports.
Without telling me what he said, were you able, was the manager of Champs able to identify it?
Yes, he was.
What was the name of the person he identified?
He identified the subject that made a previous purchase as a rapper known as Young Thug.
Was Mr. May able to identify the person who threatened him?
Yes, he was.
And how did Mr. May identify the person who made the threat?
Mr. May did an images search on his phone and pulled up a picture where he identified that person, the photograph was the one that made the threat against him.
And once you learned the person's name was Young Thug, what did you do?
At the time, I was just still gathering more information. Once I was done with that and left the mall, I went back to do I did some further searches to try and determine a government name for the individual known as Young Thug.
And what did you determine the legal name to be?
I was able to determine it was Jeffrey Williams.
Did you prepare an incident, a report for this incident?
Yes, sir, I did.
Mr. Stevens, do you recall what the language of the threat was?
It was paraphrased. Mr. May did not provide an actual quote. He just said that Young Thug said that he would shoot Mr. May in the face.
Did you take out any arrest warrants or any other additional charges?
No, sir, I did not. I completed my incident report and forwarded it to the case investigator, and the investigator is the one that swore out a warrant.
And did that complete your involvement with this case?
Yes, sir, it did.
Court's indulgence.
Yes, sir.
Mr. Stevens, do you recall Mr. Hutchins being present?
The name I do not recall off the top of my head. It's possible that that might have been one of the security officers involved, or, but the name does not, I don't recall the name off the top of my head, no.
Do you recall the demeanor of any of the perimeter mall employees?
You brought it on.
I sustain the question.
Who do you remember being present during this interaction?
I was not actually there, so I did not witness the interaction between the mall personnel and any other individuals. The only persons I spoke to were Mr. May and then the gentleman at the Champ Sports, Reggie. There were other security individuals that were involved with the incident. They actually spoke with the investigator and not with me.
Objection, that's outside the witness's knowledge.
I'll overrule the objection.
No further questions.
All right, Cross.
Good morning, former officer.
Good morning, Counselor.
Thank you for your service.
Thank you, sir.
If you need to see anything or your report to refresh your memory, just let us know. If it's in front of you, just let us know that you're looking at something, okay?
Yes, sir.
Okay. Just want to ask you a couple of things. I think this is clear, but just to breeze through this. You were not there at the time this supposed incident occurred. Is that fair to say?
That is correct.
And you get a call later through your dispatcher coworkers to come to Perimeter Mall, and you do it.
That is correct.
And when you arrived at Perimeter Mall, you met with two people. First, you met with who pronounced themselves as the security officer for the mall, named Mr. May, Christopher May. Is that fair to say?
Yes, sir. I met with him first.
And you got there, you don't have any information, so you needed to get information from Mr. May.
That is correct.
And he provided you information.
That is correct.
He was cooperative with you.
Yes, sir.
And you took notes.
Yes.
And then those notes get memorialized, is my word, but written down into a police report or an incident report. Is that all fair to say?
Yes, sir. That is correct.
And you do that timely because you go on different events for the community. So this way, when it's fresh in your mind, you write down. Fair to say?
Yes, sir.
And that's what you did in this case, right?
That is correct.
And in fact, your report, let me just make sure I'm right. Is dated the same day, 7/7/15, which is July 7, 2015.
Yes, sir. I looked at it earlier. It was written the same day of the reported incident.
Okay. And I wanted to talk with you about some things that Mr. May told you, okay?
Yes, sir.
Now, Mr. May explained to you that there were 3 men inside a white Jaguar vehicle. Is that fair to say?
At the end of the incident, yes. Initially, it started in the mall.
Okay. And we could go backwards, but that's the issue with you.
That is correct.
Okay. Anything you need to say beforehand, just let me know. Tell the insurance, okay?
Yes, sir.
But I'm just getting to the issues.
Yes, sir.
All right. And Mr. May explained that it was a 4-door Jaguar vehicle.
That is correct.
And they gave you a partial tag, that's why you couldn't run the numbers. It was just missing a digit.
Yeah, I believe it was missing 1 digit. Yes.
And then according to Mr. May, he explained to you that the rear passenger told you that if Mr. May continued to approach, he would shoot Mr. May in the face with a gun. Remember that?
That's essentially my recollection from reading the incident report, yes.
And it was that Mr. May was approaching a person, and the person said, get back, otherwise, and whatever the statement is, he would shoot Mr. May in the face with a gun. That's what Mr. May said.
That is correct.
Okay. This isn't on any recording, right?
As far as I know, it is not, sir. It wasn't recorded by me.
And when you're there at the mall
nobody else came up to you and corroborated that corroborated means
Yes, sir.
supported.
Yes, sir.
Said the same thing. That Mr. Williams, the young thug, made that statement. Is that fair to say?
During that incident, yes, that's correct.
And then Mr. May also told you that after that statement was made, then Mr. May backed away and allowed the Jaguar vehicle to leave the mall. True?
Yes, sir, that's correct.
That Mr. May was holding the Jaguar vehicle at that time. He wouldn't let it leave. That's what he told you, right?
He was trying to, what he told me, he was trying to get them to cooperate. The only thing Mr. May wanted to do is issue them a criminal trespass ban and was trying to get them to cooperate.
And the jurors may not know what a criminal trespass ban is. That means that a person or people are notified, please don't come back on this property.
That is correct. It has nothing to do with any certain type of, they have the right to say, we have a reason to ask you not to come back to the mall again. If you are, you can be prosecuted for it. So that is correct.
And because Mr. May, to his satisfaction, did not get that message across, he was detaining that vehicle, as I would explain it to you.
He never said anything about detaining, that I don't know.
He wouldn't let the vehicle leave.
When I was told after the threat was made, he backed off and let them leave.
Okay. Then, just to complete the picture for the jurors, there was a belief that Mr. Williams and others purchased many shoes at Champs Sports. You know what Champs sells? Do you
It
remember?
was sports equipment and I know some shoes, jerseys. Yes, sir. I'm familiar with it.
You realize if we go there, maybe a credit card was used.
I didn't, that was not my idea. Mr. May said that the initial incident started outside the Champs Sports. He was under the impression that there had been a purchase made, so we might have been able to identify someone through that purchase.
And that's what you did.
That is correct.
No gun was alleged to have been shown, right?
As far as I know, no one, Mr. May did not report that to me. No gun.
Said anything about a firearm being shown.
That is correct.
No one said anyone came back.
That is correct. I was not told they returned.
Okay. You wrote this up as a disorderly conduct. Do you remember that?
Do you mind if I take a look at it? I don't know if I didn't. On the incident report that I have, sir, the crime incident is listed as assault intimidation.
Do you see the top, maybe we'll look at different reports. See the top center, and otherwise let me approach and see what you look at.
Yes, sir. I have the incident report that, and I'm working.
Ron, may I approach and see what you're looking at?
You may.
Counselor, this is the incident report that I did. If it starts with Domoney Police Department, the crime is listed here. The one that I have is assault intimidation.
Can I look at it for a second?
Absolutely.
You might not want to turn the page.
No, absolutely. And then that's the end of my report there. It's just the initial back, this, and then name there, and then starting there is just further information.
I'm showing you, you know what, let me show you this return, please.
Well, Counselor, but I see what you're saying. I don't know why it is. It might have been changed because right here it
We're
says,
gonna discuss it, let me just show it to
oh,
you.
yes, sir. I'm just saying, did you see that one too, though?
Yeah.
Okay, I just want to make sure you saw it.
Show it to me.
No, absolutely.
I'm not gonna interrupt you.
It's not a problem.
Sorry, I just want to show. These are documents you brought in. I'm going to approach write you again, okay?
Yes, sir.
All right, I just want to show you.
No, certainly.
All right. Just remember.
Mhm.
So, if you don't mind looking at what, I think yours is, what is that, page 3
Yes,
that you were looking at?
that is correct.
And that's your incident report, right?
It has my name down at the bottom as the reporting officer, yes.
Okay. I'd like you to look also at page 25 on the lower right.
Ask your doctor about Nubeca.
That's the witness's report.
Good question.
Let me see it, please. What are you questioning from, Mr. Steele?
Master.
I just got the 2 babies that were good for you.
That's right.
Okay, let me see yours, please, Mr. Steele. Can I see yours again, please? Okay. Mr. Steele, in order to ask him, I'll sustain his objection. In order for you to ask more questions, you're probably going to need to clarify what you're showing him.
Can you turn to page, what is listed 25 on the documents you brought with you?
Yes, Counselor.
Okay. And is that your reporting officer narrative?
Yes, it is.
Okay. And is that either substantially or identical to what's on page 3 of the same document you came, which is also reporting officer narrative, except for what's in the center top?
The center, the narrative appears to be the exact same on both pages. There is slightly different wording at the top and at the bottom.
Now, my question to you is, do you know how on page 25, whether you put in disorderly conduct in the center for the offense?
To be honest with you, I do not recall how I termed it.
All right. Can you explain to the ladies and gentlemen jury how the report, your report, got changed or altered from page 3 to page 25, specifically from the offense, like you told the ladies and gentlemen jury what you were looking at, assault, intimidation versus disorderly conduct? Can you explain to them how that changed?
Unfortunately, I do not. When we file an incident report, we select a crime type or types. It is chosen by the reporting officer. Once we submit that report, we don't have the ability to change the type, the narrative, anything. It seems that one is dated 2015, listing disorderly conduct, and one is dated printed out 2022, lists assault, intimidation, but that could not have been done by me. I don't know how that happened, to be honest with you.
You wouldn't have done that, would you?
No, our system doesn't give us the ability to go back and modify.
And the disorderly conduct is the reporting officer narrative that was in July 7, 2015. Is that fair to say?
Yes, it says date and time of the report is July 7th. This was printed on July 9th and listed as disorderly conduct.
That's pretty much concluded your work on this case. Is that fair to say?
That is correct. After the incident report, the detective handled the case from there.
Thank you again.
Thank you, Councilman.
Any further examination? Any further redirect, sir?
Just briefly, Mr. Stevens, at the time you were interacting with Mr. May, what security personnel were present? If you recall. If you recall.
I only spoke directly with Mr. May. I know there were other personnel there on property, but I did not interact with any of them. The case investigator ended up speaking with the other personnel.
And if you recall, did anyone contradict what Mr. May stated his statement to you?
No, they did not.
I'll object to the form of the question.
I sustain the form of the question. So you can rephrase if you like.
Did anyone say that Mr. May's statement was not true?
No, they didn't.
Your Honor.
Still, I sustain that objection.
Was this a direct quote by Mr. May?
No, a direct quote was not provided to me.
Mr. Steele asked you if Mr. May said, if you approach, I will shoot you in the face. And these were not, were these exact, Mr. May's exact words?
No, sir. I paraphrase what is said. If a direct quote, such as "my name is Smith," is used, I use quotation marks to note that that is a direct quote used by an individual. Without direct quotes is only paraphrased.
Did you put? No further questions.
Anything further?
No.
All right. At this point in time, may Mr. Stevens be permanently temporarily excused as a witness?
Permanently, Your Honor.
All right. Mr. Stevens, I'm going to permanently excuse you as a witness. Appreciate your patience with us. Just don't discuss the testimony of anybody except the attorneys in this case, okay?
Yes, sir.
All right. Thank you, sir.
Thank you, Judge.
All right, call your next witness.
Your Honor, state called Sergeant Sean Lenahan to the stand.
Sergeant Lanahan?
Lenahan.
Lanahan. All right, summon Sergeant Lanahan, please. Sergeant Lanahan, good morning, sir. Sir, if you would please approach the witness stand. Once you get there, if you would turn and face Sergeant Newman and respond as a witness before you sit down, sir.
Yes, sir.
All right.
Raise your right hand. You swear firm testimony to give the truth, whole truth, nothing but the truth?
I do.
See, state spell the name of the course.
Sergeant Sean Lenahan, first name S-E-A-N, last name L-E-N-A-H-A-N. L-E-N, no, N is in November, A-H-A-N. Yes.
And Sergeant Lenahan, where are you employed?
With the City of Dunwoody Police Department,
And how long have you been with the City of Dunwoody Police Department?
11 years.
And what's your current assignment?
I am a patrol supervisor, sergeant on the road,
And how long have you served as a sergeant?
since 2015.
And prior to your role as a sergeant, what did you do for Dunwoody?
Prior to that, I was a detective in the Criminal Investigative Division, and prior to that, I was a patrol officer.
And how long did you serve as an investigator in the Criminal Investigations Division?
From 2012 to 2015, so 3 years.
And are you post-certified?
I am.
And were you post-certified on July 7th, 2015?
Yes.
If you can tell the jury briefly, what were some of your job duties and responsibilities as an investigator in the criminal investigation division?
To follow up on any criminal leads that we may have for on different cases, different types of cases, to make arrests, also to I guess make court appearances and things like that in reference to cases.
Now, in the Delaware Police Department, as an investigator in the criminal investigation division, did you have a particular area that you were assigned, or did you handle any case that came up in all of them?
Any case that came up in the city of Dunwoody.
And Perimeter Mall, is that within the city of Dunwoody?
Yes.
I want to direct your attention to July 7th, 2015. Did you have the occasion to investigate a terrorist threat incident that occurred at that location?
Yes, ma'am.
How did you first get involved with the investigation?
There was a police report made, and it got assigned to me.
And who made the police report?
Officer Mark Stevens. Mm-hmm.
And you said, that yes?
I'm sorry, yes, ma'am.
And what was your understanding of what you had to investigate?
My understanding was that there were two gentlemen at the time riding foot scooters or hoverboards.
Who was that?
Is that Mr. Steele? Yeah.
Your Honor, the testimony has comment is no longer here. Mark Stevens just testified.
Yeah, I'm gonna, well, why don't you, I'm gonna stand the objection, lay a little more foundation.
When you got the police report, did you review it?
Yes, I did.
And once you reviewed it, what was your understanding of what you needed to investigate?
Objection.
I will rule the objection.
Go ahead.
Okay. My understanding was a terroristic threat of a person threatening to shoot another person in the face with a gun.
And in order to investigate what occurred, what did you do?
So I set up a meeting with the witness and the victim, or the victim and the witnesses that were present. And then I went over to the mall and met with the three, I think it was three witnesses and the victim. And sorry. Okay. So then I asked them to write statements, and then I would come back and pick them up. Each person to write their own statement, and I would come back and pick it up. And then I left the office, and then I went back and did other things and came back and picked it up another day.
So let's slow that down.
Okay.
You went super fast.
Okay.
All right. So you said that your responsibility was to investigate a terrorist threat.
Correct.
And when did you first get the police report handed to you? Do you recall?
I believe it was July 7th, 2015.
And let me first ask, on July 7th, 2015, you first get the report from Officer Stevens. Did you go to the mall on that day or another day?
I believe it was the next day or the day after. I'm not sure the exact day, but it was shortly after that, yes.
And when you went to the mall, what did you do?
I met with them in the security office.
So let me ask you, said them.
I'm sorry, the victim, Chris May, and the three witnesses, turned out to be three witnesses that were present during the threat.
Okay, so you said Chris May was the victim. Who were the three witnesses that you met with?
The exact names, I think Hutchins was the last name of one of them. The other one was, can I look at my notes or do you want?
Well, let me approach. We're looking at a copy of your report, refresh your memory as to who you spoke with.
It would, yeah.
Okay.
Mm-hmm.
I want to show you what will be marked as State Exhibit 191P, and I can show it to you. I'm going to show him the entire page. I'm going to refer him to. I'm going gonna show you, oh, thank you. What's been labeled as State Bill 191P to help refresh your memory. I'm gonna direct your attention specifically to pages 28 through 31. Tell me if that helps refresh your memory as to the three witnesses that you met.
Christopher May is the victim, and then, yes, Officer Hutchins and Campbell and Barron.
And first with Officer Hutchins, what was Officer Hutchins' first name?
Right.
And what about Officer Campbell?
Officer Campbell, I don't remember his first name.
Okay. And what about, you said that one was Barron?
Yes, his name is Jonathan.
All right. And you said you met with them at Perimeter Mall. Where in Perimeter Mall did you meet with them?
In the security office.
And while in the security office, were all four of them together, the victim and the three witnesses?
Yes, they were present.
What do you recall about your initial interaction with Mr. May, Mr. Hutchins, Mr. Barron, Mr. Campbell while in security?
They seemed concerned about the threat and the possibility of it being carried out. They didn't.
Hold on.
Confrontation clause.
Your Honor, it's an observation.
It's not an observation.
Your Honor,
I'll sustain the question as to form. Why don't you rephrase?
what was your observation of the individuals as you were speaking with them?
I observed them to be concerned about the possibility of the threat being carried out, and that they were wondering and asking questions about what we might.
Your Honor, hear that said?
I'm all over the objection.
Go ahead.
They were asking about what was going to be, what were the next steps, what was going to happen after we met.
And while you met with the four individuals, did you instruct them to do anything?
Yes.
What did you instruct them to do?
I instructed them to individually make statements or write statements as to their recollection of the events,
Why did you ask them to each write their own statement?
because that would be their individual, it wouldn't be one collective statement, it would be that they individually stated what they saw happen or what they recollect of the event.
And did you tell them how to write it? Did you tell them to type it, to handwrite it? Or?
Well, I instructed them to handwrite it, but then they came back and they typed it.
So you gave instructions for handwriting, but then they typed it.
Objection, asked and answered.
I sustain the objection. That's the answer.
When you first met with them, did they give you their statements on that day?
No, they did not.
Once you gave them the instructions to write a statement out, what did you do? Did you leave?
I did, yes. I left.
And do you recall when did you go back to get the statements?
I did.
When did you go back to get the statements?
Came back. It was I would say it's about a day later, a day and a half.
And when you went back to get the statements, where did you go?
Back to the security office.
And what happened once you went back to get the statements at the security office?
They each gave me their statement from their hand to mine. They directly gave it to me.
When you say they each gave you their statement,
Mhm.
explain.
I asked them each for their statements, and they took the paper and handed it to me.
So Mr. May gave you his statement?
Correct.
Did Mr. Hutchins give you his statement?
Yes, correct.
Did Mr. Barron give you his statement?
Yes,
And Mr. Campbell gave you his statement?
yes.
Did you ask them any questions about their statements?
No, we did not.
And I think you just testified when they gave you back the statements, were they handwritten or typed?
They were typed. Hand signed though. They had handwritten signatures. Mm-hmm.
Once they gave you their statements, did they appear that they were forced to give you the statements?
No,
Did they appear as if they didn't want to give you the statements?
no.
Permission to approach?
You may.
I'm going to show you what's been marked as Stacy's Exhibit 190P. Do you recognize Stacy's Exhibit 190P?
that the same as you showed?
That's the same one I gave you from earlier.
I recognize it as Mr. Dwight Hutchins' statement.
And is that the same statement that you received from the White Hutchins hands back in July 2015?
Yes.
And does that appear to be the type statement with the signature of the White Hutchins that you received from him back in July 2015?
Yes.
During this time, state like tender states to the 190P into evidence.
Any objection to states 190P?
Yes, sir. It's a written document. It would not go back with the jury, and it's not, there's no question, just identifying something.
Can you all approach a second, please? Okay, it's Talk Radio. Okay, I'm going to overrule the objection of Mr. Steele. I'll notice continuing.
Permission to publish, Your Honor.
You may, madam.
Okay, now, Mr. Sergeant Lenny, I want you to read it from top to bottom.
Just a statement, madam.
Just a statement.
Just a statement. The entirety of it.
Okay. On July 7th, 2015 at 16:40 p.m., I, Officer Hutchins, approached two black males about to go down the center court escalator on motorized mini Segways. I spoke to both the males and advised them that they could not ride the mini Segway in the mall due to mall policy, and it's very dangerous to get on the escalators riding them also. The two males ignored me and the mall policy that I quoted them. I then called dispatch to advise them of the situation, and I also told them to call Dunwoody. Director May then called and asked for my location. He met me at the lower level Macy's in front of Champs. We waited on the two males to come out of Champs. As they exited the store, Director May spoke with them and also quoted the mall policy to them again, and they also ignored. They kept riding the Segways to the center court and was saying that that we are leaving, as Mr. May was telling them that they needed to get off the mini Segways. They went on the escalator on the Segway and out upper level Main. Mr. May was still trying to get their attention while advising them of the mall policy. Outside upper level Main, they were greeted by Supervisor Barron and Campbell, who also quoted mall policy to them, and they ignored them also. At East Main Valet, where they were parked, Mr. May was asking them to leave the property, and one of the males shouted out that they would come back and shoot Mr. May in the face, and from there, Mr. May told dispatch to call Dunwoody Police.
And was that been signed by Mr. Hutchins?
Yes, it was.
And what's the date of the signature?
7/7/2015.
And again, this is what Mr. Hutchins handed to you.
Yes.
All right. Now, when Mr. Hutchins gave this to you, either on the day you picked it up or when you first gave him the instructions, did he appear as if he understood what you were asking him to do?
Yes.
Did Mr. Hutchins ever indicate to you or give you any indication that he was forced to write this statement?
No.
When he handed it to you, did he give you any indication that that was not his words or what he was relaying happened to him?
No.
When you initially gave the instructions to write your statement, did Mr. Hutchins ask you any questions? Do you remember him asking you any questions about what to write in the statement?
I don't know. No.
Now, once you received all of the statements from Mr. May, Mr. Hutchins, Mr. Barrett, and Mr. Campbell, what did you do next?
I left the location.
Did you eventually take out charges for Mr. Jackie Wood?
I did.
And what charges did you take out?
1 count of terroristic threats.
And And why did you take out the terroristic threats warrant?
I had corroboration of,
Base it. I'm overruled objection.
I took out the threat because I had the corroboration of three witnesses that heard the threat, and the threat is to harm or seriously injure or kill Mr.
And
May.
use the word corroboration, what does that mean?
The three witnesses all had the same recollection of what happened, and they stated that to me.
If you did not have corroboration, we would take out those warrants.
No.
After taking out this warrant, as it relates to solely the terroristic threats portion of it, did that include your fault?
Yes.
Portion of it. No further questions.
Cross.
Oh, before you begin, I'll admit, it's just H 190.
Yes. when I-
I'll admit over with the objections that were made.
Good morning, sir.
Well,
I'd like to ask you some questions. Start with corroboration, okay?
Okay.
Ladies and gentlemen, the jury, the three witnesses you're talking about is Mr. Hutchins, correct?
Yes.
Mr. Barron, correct?
Correct.
Barron, if that sounds right.
It sounds correct. I'm not sure.
And Mr. Campbell, Campbell, fair?
Yes.
Tell the ladies and gentlemen, the jury, whether any of those witnesses said that Mr. Jeffrey Williams, young thug, person in the back seat, person in the front seat, made that statement that you're telling the jurors.
Objection, compound question.
That's the standard question. You can just break it up, Mr. Steele.
Did Mr. Barron say that Jeffrey Williams, young thug, or a specific person identified in any way made that statement that we're talking about to corroborate Mr. May's statement that it was said by Mr. Williams?
No, they did not.
Did Mr. Campbell say in any way that it was Mr. Williams, young thug, or, a description of this is the person sitting here wearing this, looking like that, made that supposed statement?
In their statement or just, okay. Not in their statement.
Okay. And did Mr. Hutchins, the jurors already saw it, did you read it? He also said one of the people said that, right?
Correct.
And that was consistent throughout, correct?
Correct.
Now, when you explain to the jury, I think you remember meeting with these three people and Mr. May in a room. Is that what you said?
Correct. The security office.
And do you know what was discussed, if anything, about this incident, about what supposedly went on and what people heard before these statements were written between the three of them? Or
No.
them?
No, sir, I don't.
You wouldn't have any knowledge.
No, sir.
And when you were asked by the district attorney whether you took out a warrant for terroristic threats, you're aware the district attorney office in DeKalb County dismissed this case, correct?
Yes.
For no corroboration, correct?
Objection, speculation.
I'll sustain the objection.
Do you have it in your report in front of you?
That is what that says.
I couldn't hear you, I apologize.
It says lack sufficient corroboration that the threat would be consumed or consummated.
And it's me, I'm confident it's me, but I couldn't hear the end. You said lack sufficient corroboration, then you started to say something.
I'm just continuing to read. It said, was conditional and lacked sufficient corroboration that the threat would and could be consummated.
And that was pretty much your end of the saga in this incident, correct?
Yes.
Just so the jurors know, there's no recordings or anything that you could share with them about meeting with any witness. Is that fair to say?
No, sir.
Am I correct?
You're correct.
Thank you, sir.
Yes, sir.
Thank you, Your Honor.
Any other examination? Any further questions from the state?
Sergeant Linehan, Mr. Steele asked you about whether or not in any of the witness statements did they mention Mr. Williams or Young Thug?
Mhm.
You recall that?
I do.
With all of the statements, did they indicate how many males made that statement? They said it was one male, two males. Do they indicate?
I think they did say one of the males makes the statement in each one, but they didn't specify.
Just confirm, they, each of them, they say one of the males.
Basis. I sustain the question.
Given what Mr. Steele asked you, and looking at any of those things, would it help refresh your memory as to how the witness identified the individual who made the threat about shooting someone?
I'm sorry, can you repeat?
Sure. Looking at the three statements, would it help refresh your memory as to how they identified the person who made the threat?
They identified the man who made the threat by looking at him and then speaking with the manager at Champs, and then the photos on the internet is how they identified exactly who he was. The manager at Champs said that it was.
Sustain objection.
When each of the individuals who wrote their statements, you had three witnesses.
Yes, ma'am.
Did they indicate if it was only one of the males that made that statement about shooting?
Only one of the males, yes.
Only one of them.
Mhm.
Now, Mr. Still asked you a lot about what the district attorney's office did. As a law enforcement officer, do you have control over how the district attorney's office disposed of their cases?
Oftentimes, no.
Oftentimes. When you took out your warrant, did you, based on your experience, take out based on the corroboration that you had?
Yes.
And in your experiences, has the district attorney's office in DeKalb County done things opposite than the warrants that you've taken out?
Yes.
So this is not the first time that has happened for you?
No.
I have no further questions.
Anything further, sir?
Sergeant, point to where in any of your reports dealing with what we're calling the three witnesses, Mr. Hutchins, Mr. Campbell, or Mr. Barron, does it say anything about looking at a photograph, identifying Young Thug, identifying Mr. Williams as the person who made that statement? Anyway.
From the witnesses?
Sure. That's what we're
No,
talking about.
It's in the victim's written statement.
Okay, now you say the victim, that's Mr. May.
Right.
I'm ignoring because you separated him from the three witnesses.
Well, when they went back to the store.
Matt, we should be looking at the report done by Officer Stevens?
No, I'm looking at Mr. May's statement.
Okay, well, okay.
Mr. May's statement is when they went back to, I'm sorry.
Well, let's be specific. Who is they?
Okay.
You know, I don't mind talking, but just instead of using the word they in Mr. May's statement, who you?
It says, Thunder Officer Stevens arrived and together we went to Champs, where the manager of Champs, Reggie, informed us that the male who was on the device was a known rapper by the name Young Thug.
Now, that is Mr. May, Christopher May,
Yes,
according to Mr. May's statement, right?
yes,
Officer Stevens, a coworker of yours at that time,
yes,
and speaking with a gentleman from Champs.
correct.
I just want to make sure. That's the entirety, right?
Yes.
Thank you, sir. Thank you, Your Honor.
Anything further? You state.
No, I'm saying.
All right. At this point in time, Sergeant Lanahan be permanently temporarily excused as a witness.
You can be permanently excused.
All right, Sergeant Lanahan, appreciate your patience with us. I'm going to go ahead and permanently excuse you as a witness, so you're free to go about your usual duties and navigation. Just don't discuss the testimony and except the attorneys in this case, okay?
Yes, sir.
Thank you, sir. All right. All right, ladies and gentlemen, it's about 5, almost 10 after 12. How about some lunch? All right, excellent. Okay, ladies and gentlemen, we're going to go ahead and recess once I finish all my announcements and pronouncements to you, and ask you to come back for 1:30. Okay. Remember all of my ad nauseum admissions here at this point in time. In particular, are you okay? Are you allowed to, now that you've heard some more testimony, discuss the matter in your headquarters jury liberation room? No, you're not. Okay, all right. And remember all the other things that I told you in terms of just your behavior up to this point in time. Do not discuss this case amongst yourselves in onesies and twosies. Don't discuss anything that you might have heard in the courtroom today until such time as the court gives you instructions on how you to consider what you've heard within the four walls of this courtroom. If anybody should try and touch base with you in any form of transmission, email, text, phone call, or otherwise try and talk to you in person, please, you need to let Sergeant Ingram know immediately and let me know. All right? Okay, ladies and gentlemen, it looks like for the after we come back from lunch, we should have a regular workday conclusion, and then we'll see where the rest of the week leads us at that point. Okay, any questions of me? Okay, all right. Enjoy your lunch, and we'll see you back at 1:30. Okay, all right. All rise. He's ready to go. He's been ready. Okay, our jurors left us. You may be seated. All right, councilors, I'll see you all back for 1:30, okay? And we'll start back then. All right? Okay, we're in recess.
Going to merge their questions in here for the 2024 first question of the year. And do you have any idea of how many witnesses that we can expect here? And generally, what's this trial about?
Yeah. Well, thank you both for those questions. In terms of generally how many witnesses we have, don't forget, when we start off this trial, the judge restricted or tried to restrict the prosecutor from that 700 plus witness list down to 400, something that was manageable. But because of the stall in the case, I think we're still looking at hundreds of potential witnesses coming up. We really haven't gotten to the meat and potatoes of this case. And what overall this case is about is it's a RICO case. And so what the attorney in Georgia is saying is that this gang, YSL, has intricate criminal and some non-criminal activities that lead to the furtherance of a gang. And so it could be purchasing a vehicle that was used in a hit and run. It could be possession of a firearm, possession of drugs, intimidation, murder. All of these crimes are supposed to be intertwined towards the furtherance of the YSL gang, with Young Thug as the quote-unquote king slime, as the prosecutors believe.
Okay, excellent, excellent. Gene Rossi, I'm going to merge two more questions just to make sure that we're fair and balanced here and that you get a double whammy as well here. So we have Jerry Michael QQQ from YouTube and Mr. Mike 070 from YouTube. And here are the combined questions. How will the state tie everything together after this being such a long trial to prove RICO? And similarly, in your opinion, up to this point, has RICO been established by the state? If not, what else does the state have left?
Well, first off, what they've charged is a racketeer, influence, and corrupt organization. You need an enterprise. This gang is the alleged enterprise. And all these acts that they're going to bring into the trial are in furtherance of the enterprise and to maintain it. So to answer the question, have they proved RICO? I would say they're moving in the right direction. We just had at least two great football games yesterday. So we're moving towards the goal line, but I don't think we're there yet. Now, here's the thing. Here's my concern about having 700, 400, or over 200 witnesses. And all of us here have tried cases that are lengthy. You're going to bore the jury with too many witnesses. So the prosecution needs to be careful in selecting those witnesses that are absolutely essential to the RICO and don't cause the jury to make their eyes glaze over. So Mike's question, Jerry's question is very valid. If this trial lasts 6 months, I think that's 2 months too long, in my humble view.
Yeah, and Gene, I've also found too, when you have a really, really lengthy trial, I tried a case one time, it was 2 years in the making. You got to be precise, you got to keep their attention, but I think that if you put too many witnesses on, it looks like they're stretching, like they really don't have a lot when you're putting all these little dots together. So it's such a strategic question. Brian, let me go to you. This is Chitin Lily. I'm sorry if I'm getting that wrong. Chitin Lilio from YouTube. What does the mall incident have to do with the RICO charges?
Leo, thank you for that question. I think I might have missed some of the testimony in this, so please correct me if I'm wrong here. It's again another aspect of RICO, in that the defendants who were participated in the mall incident are doing something to further the enterprise. And I think that's the difficulty here that Gene is kind of alluding to, in that how do you take all of these witnesses and tie together all of these actions to say that they're furthering the gang? And I think the difficulty in this mall incident that you're kind of alluding to as well is that, does it seem all that criminal? And the answer is, it doesn't need to be criminal to be in furtherance of a gang. I know I say this facetiously sometimes to my wife when she asks. I said, if YSL technically had a bake sale selling gingerbread cookies or leftover Christmas cookies, and those proceeds went towards furthering the gang, then that cookie sale can technically be a RICO violation. And so sometimes it's hard to predict what is in furtherance of RICO. Sorry, you just got to see how it all connects together at the end.
Brian Buckmeyer with the gingerbread cookie, bringing a little bit of the holiday bakery into the analysis. I love it. Okay, on that note, we're going to take a quick break here on Law and Crime. We'll be back on the other end with more of your questions, so please put them in. We'll be right back.
Train station.
Welcome back to Law and Crime. We're catching you up on the testimony from this morning in the trial against Young Thug and the co-defendants. Court resumed today after an extended hiatus following the stabbing of a co-defendant in the case at the Fulton County Jail. The jury's been sent away for their lunch break, where they are due to come back around 1:30 p.m. Eastern Time. And while we wait for court to return, we're continuing to take our questions live with our legal panelists. If you have any questions for us so that you'd like us to answer, please post your question in our YouTube chat or on social media, because we're watching and they're feeding it to me. I love this question, Gene Rossi. It implicates so much nuance about the reality of the trial world, and it's not legal. It's all about human nature. So Jerry Michael QQQ from YouTube asks, how do you think the state decides which attorney questions which witness? And let's of course say ego never comes into the equation. Never.
Okay, putting aside ego and competence, I just finished a trial. I didn't prevail. But when you decide who does a direct exam or cross-exam of a witness, it's a dance. And you have to complement each other. So you want an attorney that is going to get along with the witness whom you're calling. There has to be some chemistry. I can give you 20 to 30 war stories that illustrate that. My style, I am patting myself on the back. I consider myself very easy to get along with, and I calm witnesses. You don't want a prosecutor or defense attorney who raises the anxiety level of the witness so that they're freaking out, if you will, before they take the stand. You try to have somebody that can calm them. I think I can do it well. The opposite is you want somebody in cross that is not going to be obnoxious, but will be aggressive. And so that gets into another dynamic. Who's going to cross this particular witness? So those are things you have to consider. But who dances with the witness, whether direct or cross, is a crucial decision of a prosecutor or defense attorney.
Yeah, I just to add my own 2 cents into that question, because I really love it. It's very difficult when 2 lawyers are trying a case, especially as prosecutors, because there's a lot of you're into it. You've got a lot of heart into it. And I can remember a case where we literally debated tooth and nail who was going to cross-examine the defendant if the defendant took the witness stand. And even though we got along very well as partners or whatever, I was hungry to do it and he was hungry to do it. And we had to come to a resolution. But listen, all those things are important. What's most important is who's got the better skill set to cross-examine that particular witness. Not every witness is the same. Brian, so do you have any insights into that? Because I think that's a really good question. And I don't think that's such an easy answer. I think sometimes it literally waits, at least it has for me, until the time comes a witness is going to take the stand on cross.
What I often do, even in planning the trial, is I try to have a co-counsel who is different than I am in terms of personality, sometimes the way that I look. I often like to do trials with my good friend Anna Carlson, who's a very tall, kind of like mixed complexion, attractive woman. And the reason why I do that is because there are witnesses who sometimes the jury doesn't mind if a very large man yells at them. Sometimes I can get away with yelling at a cop and the cop will respond back and forth and we can spar. But I'm not going to do that with a female victim, for example. I may ask my co-counsel, who is a woman, and they can talk to that. The way I think about it is, who will the jury allow me to be when in front of that witness? And is that person the appropriate person to cross-examine them as a defense attorney? And so that's how I look at it.
Yeah, and Gene, let's play this out, because that's a really good response that Brian's given. How you're cross-examining a witness. When I was training, saying you're not one speed with every witness. You have to understand the jury. You have to understand the witness. A lot of times you have to wait for the witness to become like a little bit of a wise person or whatever before you get into them, because it could look like you're beating them up. So your cross-examiners, and any lawyer for that matter, has to be very flexible to make sure that they're able to get data from the witness but not offend the jury. Do you have any thoughts on that?
Oh, and that's addressed to me. Absolutely. And in the case I just finished, there was one witness, there was a female witness, and I stood up, I just said my name, I said, good morning, thank you for coming. And from the word go, she treated me like I was Darth Vader and I was the evil Empire. Now, if you have a thin skin, you're going to take that personally. But in front of the jury, you've actually won the case or won that witness with just your introduction, because they have become a Jekyll and Hyde witness. And on cross-examination, this is the key for me: is they're going to do great on direct. If they don't do great on direct, then they really lost. But on cross, you want to puncture that professionalism, that calmness with your cross, and you have to do it in a way that doesn't offend the jury. And Brian brought up a good point. Female attorneys can do certain things with female victims that I could never do. I would look stupid if I did it. But female attorneys can do things with female victims that are appropriate, professional, and ethical, and I can't do that. And I realize that's not one of my strengths.
Okay, yeah, you have to know what your strengths are as a lawyer. I think that's very important too, especially if you're trying with a partner in a case. All right, I'm going to try to combine, Brian, two more questions again because they're kind of similar. Cavell O from YouTube asked, after such a long holiday break and with the state resuming as they left off, not really tying this to RICO, could this lose more jurors? Okay, time off, not even time connected to RICO. And then Rachel Ellis from YouTube asked, how is the case going so far? Is defense cooking? Now, I'm presuming this is not about food. We're talking about, are they cooking in terms of doing a good job? So exactly, it is the holiday season, but I had enough to eat for cooking. So let's move away from the food cooking. What do you think, Brian?
So I'll start from the first question. Yeah, timing is an issue, but it's an issue for two things. One, this jury was told that they may be here for 6 months or so. When you take off December 11th to January 2nd or 3rd, whatever it is now, I'm still kind of on the holiday myself, I guess. That time wasn't allocated to be how long this case will extend. So you've got to think about timing on the back end. Are you going to lose potential jurors who say, I've got to go to work, I've got childcare, I've got a life, I can't sacrifice this much time? And that's a possibility of a hung jury or a mistrial because you don't have enough jurors to deliberate on the case. And then also just remembering what happened before. Now, I'm not really concerned about them remembering things that happened in December from today. I'm concerned come summation when it's 9+ maybe months. I don't know how many delays we're going to get in this case. When the prosecutor is saying, oh, you remember what happened December 1st of 2023? And we're somewhere in the middle of July or August, that's going to be difficult for them. And then in terms of the defense cooking, I think they want this case to stay with the heat on, cooking for a long, long, long time because the defense is hoping the prosecution burns the meal for the jury. They're hoping that time destroys this meal for them. I don't think they're in any kind of hurry to get this case through because the longer this draws out, the more the jury forget, the more the jury will be like, how is this connected? And I think that's a plus for the defense.
Yeah, that's really true. And I'm sure prosecutors, if they're any good, and I think they are, they're concerned about that very thing that you just brought out there. It is a really, really tough balance in a case where you have so many witnesses, so much complexity, and so much time going by for prosecutors. Okay, guys, excellent commentary. Of course, I don't expect anything different in 2023, 2022, 2024. These two guys are the best. We're going to take a quick break. We'll be back with more of your questions. If you have them, put them in the YouTube chat or on social media. We'd love to answer them. We'll be right back.
Hello, William Walker here at the Sit and Sleep at Walker's. We literally have hundreds of sofas, hundreds of recliners, big man recliners, lift recliners, only $5.94, adjustable beds, only $6.44, includes a mattress, queen size. That's at the Sit and Sleep at Walker's on the 123 bypass in Easley, where we have easy payments or no credit needed or up to 12 months interest free.
And my papa puts on a sale, he puts on a sale.
Okay, the jury is currently on lunch break in the trial against young rapper and the co-defendants. They're back due in court around 1:30 Eastern time. So we're continuing to take your questions live with our panel. If you have a question you'd like to pass on to us, please post it in our YouTube chat or on social media. Now, we can have a little fun, guys, because this is the first show of 2024. Okay, so I'm taking poetic liberty to have a good time as we roll into the next season. So Brian used an analogy before, about making gingerbread cookies, okay, for the cooking question. And so I have a question for Brian. It's not in the chat. It's a Bob Bianchi question. Brian, for a night out, fun and frivolity from me, what is Gene Rossi's favorite food to eat during the holiday season?
Polenta, isn't it?
Oh my, you got it. You got it.
Is that it?
Oh man, I'm done.
Polenta?
Yeah, it is. It's polenta.
Excelsior. Got it.
But you gotta mix polenta with something. You can't have it by itself. You have to have a sauce, a cheese, something. It can't be a standalone appetizer.
See, Brian, personally, I've always argued with Gene about this because if you have to add something to it to make it good, it's not good in the first place. But listen, I don't want to get into a war about Italian food here with Gene, of all people. Great job. Okay, guys, so let's go back to a question here that has been hot. Now, Big Facts TV is talking about the judge allowing lyrics to be used in the courtroom. Gene, I know Brian and myself talked about this the other week. I'm just curious. I haven't gotten your opinion on this. Fair game or not? And I think it could be wrought with problems, but is it fair that prosecutors are able to use these lyrics?
Absolutely, because the defense, at least one defendant, is arguing that this is not the name of a gang, it's the name of a record label. The Young Stone Life, I guess it is. So the prosecution has the right to use lyrics that show that it wasn't a record label, it was a gang. And that's relevant to the RICO and all the other things that are part of the charge.
Yeah, Brian, I before we ask you the same question, I mean, the judge did, I believe, based on my understanding, eliminate some of the lyrics. And, the judge has to make a determination as to, under the evidence rules, whether it's relevant, that's number one for any evidence, whether or not it goes to motive, intent, opportunity, plan, preparation, mistake, things of that nature. But also under evidence rule 403 wants to make sure it doesn't create undue prejudice, confusion with the jury. So the judge kind of had a middle of the road approach here. And typically speaking, I just want our audience to understand that sometimes a court could say, look, I don't think it's very persuasive, but that goes to the weight the jury is going to give that evidence as opposed to whether or not I'm going to completely not allow it. Can you talk to us a little bit about your thoughts?
Yeah, so the history of this, as people probably know from following this case, is that it happens a lot. I'm sure I've represented clients where their rap lyrics have been used against them. I'm sure we've all seen this in cases. This is where I come down on it. And it's similar to how the legislature in California has been arguing that it should be used after the YSL case. And many people like P. Diddy and Jay-Z got involved for advocating against this. If you can prove by preponderance of the evidence that these rap lyrics are actually connected to a crime, then I say by all means, go forward and use the rap lyrics. But for example, one of the rap lyrics that are being used against Young Thug comes from a song by him and Nicki Minaj called Anybody, where he says throughout the rap lyrics, I have nothing to do with that body, but I got something, so I didn't kill anybody, but I got something to do with that body. And they're trying to use that lyric to then say, well, when he purchased a vehicle for other people to then commit a murder, that is him rapping about it. And I'm thinking to myself, whoa, that is far, that's a far leap. Now, can you make that articulate argument in front of a judge and say, yes, it's relevant because he's talking about not actually committing murders, but furthering a gang to commit the murder? Sure, you can make that argument. But now you can pull in any amount of rap lyric. And in terms of the last part, in terms of 404B, and where we talked about the undue prejudice, rap by its nature, especially gangster rap that became very popular in the 90s, is full of hyperbole and other forms of lyrical analysis that is used to further the idea of violence to get more sales. And so if people are creating music to become more violent to get sales, for them to then turn around and say, well, we'll prosecute you for it as well, does have a chilling effect in terms of both the art and in terms of prejudice. I always make the argument, no one went after Bob Marley for shooting the sheriff. No one went after Eminem for all the domestic abuse he supposedly put in his lyrics. No one went after Johnny Cash for shooting a man in Reno just to watch him die. It always happens in one genre of music, and that's where people argue the prejudice exists.
And let's just, for a full record, make sure it's clear, he didn't shoot the sheriff, he shot the sheriff, but he didn't shoot the deputy.
Exactly.
But he didn't shoot the deputy. Okay, very good, Brian. Okay, really good question here from Tallglass from YouTube. And again, we're getting into evidence issues, right? And I really love these questions because there's a book of evidence that tells you what can get in and what can't get in. And so often people have like a knee-jerk reaction, what they think should get in, but it's not necessarily what the evidence rules say. That's why lawyers have to know the evidence rules like the back of their hand. So here's the question from Tallglass. Should the judge have stopped Mr. Hudson's testimony as he clearly had a medical impairment hindering his ability to recall? Gene Ross.
Well, I think a judge has a lot of discretion in allowing a witness to testify because they make the determination under the rules of evidence. A judge makes a determination at the beginning whether a witness is qualified to testify. You take an oath, you're with it. You have the capacity to remember things. What this question is addressing is when a witness is saying they can't recall or they have faulty recollection, that goes to the weight, not admissibility. That goes to the amount of credence the jury gives the witness if a witness has a faulty memory, is misremembering things, is forgetting things. So those are two different things.
Right. Once again, Gene, we're talking about the difference between something being admissible as opposed to a judge saying, look, it may be weak evidence, but that's up to the jury to determine the weight they're going to give that evidence. So, but it's a very, very good question. And of course, the lawyer's job is to make a witness on the other side look as if they can't recall, they forgot, they're lying, they're fabricating, all going to the weight of testimony. Great question, though. Brian, do you have any thoughts on Purple Dinosaur asking, how does the jury isolate themselves from outside influence over such a long trial?
Oh, Purple Dinosaur, I think is one of my son's favorite animals right now, actually. So thank you for the question. I have a lot of thoughts, not only in terms of the length of the case, but also the length of this break. Now, Gene kind of talked about in other situations where the judge has a lot of discretion. I understand why a judge would say, we are not going to do a mistrial after one of the co-defendants gets stabbed. We are just going to wait. But that wait from December 11th till today had Christmas, Hanukkah, Boxing Day for those Canadians and people from the UK who celebrate, Kwanzaa for those who celebrate as well, the New Year's. You're with family, you're with friends, you're traveling, you're listening to the radio. You're probably seeing Bob Bianchi and Gene Rossi somewhere at Law and Crime, and you're hearing part of their expert in legal analysis. It just becomes that much more dangerous and that much more possible for a jury to hear information they're not supposed to. But again, it's a balancing act. We took so long to get to this point to pick a jury. I understand why the need to push this through, but I think this case is going to be ripe with appeals when we get a verdict, whenever that is, with did a jury hear this, did a jury hear that, whatever it may be.
All right, guys, Gene, we have some good kind of lawyer-like questions, and I'm gonna ask you is, when this kind of question is asked, it's not only relevant to somebody with a big defense background like Brian's got, but also a big prosecutorial background like you. We're all observing what's going on in that courtroom and how it's affecting the jury. That's the most important thing. So Teresa Trice from YouTube asks, how do you feel it makes the prosecutor look that a retired officer verified that his report had disorderly conduct versus a report dated years later that it was changed to assault?
You know what? Something is rotten in Denmark. I got to tell you, that little nugget and that Teresa picked up on this. That officer said when I inputted it was disorderly. And I think I did it in 2015 and I couldn't touch it once I put submit. That draws a conclusion, and defense attorneys are going to latch onto that there's confirmation bias, there's hanky-panky, and someone later on changed the narrative and altered that report. That looks incredibly bad. That is obstruction. That is obstruction classic. So the jury's going to be reminded of that during closing about that little nugget. I found that testimony, that little bit, very interesting.
Brian, I was very disconcerted to hear because I'm seeing more and more of this going on. And I go back in a day where there wasn't monitoring reports. And if you pushed the button, it logged it and it had a number associated with it. I'm seeing more and more of this creative police report writing or things changing and you get a record that says something different. When you try to drill down on it, all of a sudden nobody has any idea how the system works. Nobody, it's amazing to me. And of course, in the real world, trying to get a judge to say, Judge, we want information on the computer system, the IT, you get kind of pushback. Well, that's a fishing expedition. No, here a report has changed. And as a lawyer, with the skill set that you have here, to Gene's point,